Good afternoon, everybody. We're starting a little bit early just to let folks get settled on in. We'll begin at noon, giving a minute for everybody to get settled. Thank you. Welcome, folks. We're just letting everybody settle on in. We're going to begin at noon on time. Welcome, everybody, to the 2024 legislative update. My name is Alexis Alvarez Bartholomew, and I am the Director of Statewide Training at Florida Legal Services. We have a lot of content here for you today, so I'm going to do my best to make the housekeeping announcements short and sweet. First off, this is being recorded, and you will receive a copy of this recording. Second, closed captions are enabled for anybody that does need extra accessibility. If you have any issues onboarding that, please reach out to me privately in chat. Third, this is approved for CLE credit through the Florida Bar. Additionally, we will provide on a request basis certificates for anybody else, certificates of attendance for anybody else who does need that. The process for getting that certificate will be emailing me directly. I am going to drop my email into the chat as soon as I turn over to our speakers. Please feel free to reach out to me for anything that you need. Important housekeeping announcements we'd also like to mention, because we have such a great deal of content, we want you to know that the PowerPoint will be provided to you all as a handout after this session concludes. So don't worry, you will have a copy of the PowerPoint to go back and look at along with the recording. Additionally, questions and answers, please drop those questions into the Q&A. That is the easiest way for us to filter all of your important thoughts. Because we have a lot of content today, we are going to push through the content as efficiently as possible, which might not allow as many moments for in-person live time question and answer. But afterwards, our speaker will stay on to answer any questions that you need within the time frame that she has. And so with that being said, I'm going to turn it over to our speakers here today. I am very honored to share this platform with Deputy Director Robin Rosenberg and Executive Director Geori Seldine of Florida's Children First. Robin, Geori, thank you very much. The floor is yours.
Thank you, Alexis. Good afternoon, everyone. Thank you so much for joining our training. My name is Geori Seldine, and I have the honor of being the Executive Director of Florida's Children First, a nonprofit independent advocacy organization committed to protecting and advancing the rights of children and youth that are impacted by the child welfare, juvenile justice, and disability systems. And we do that through systemic reform, education, youth voice, and promoting high-quality legal representation. Through our programs and our advocacy, we work together to create long-term sustainable improvements to Florida's child welfare system to produce better outcomes for Florida's children. In 2005, when we were advocating for changes for many years, we realized that something was missing in Florida. We needed individuals who were experiencing the system firsthand to inform Florida's Children First of those issues. So Florida's Children First launched a youth-led organization called Florida Youth Shine. Since 2005, Florida Youth Shine has become a dynamic, statewide, youth-led organization continuing to be supported by Florida's Children First. It's made up of advocates ages 13 to 26 who advocate for powerful change and use their voices and experience. And we have over 14 chapters around the state. Florida's Children First offers many programs such as Florida Youth Shine, and we have a lot of great resources that we encourage you to check out. Please visit our website at floridaschildrenfirst.org for lots of great information. I would now like to turn it to Robin, who will be the host of today's training.
Good afternoon, everyone. Thank you for joining us. We have, as Alexis told you, a lot of material to cover today. Not a lot of bills passed, but the bills have a lot of content. So unlike most of our trainings where we can stop and chat and handle questions, I probably won't be able to do too much of that today. And again, want to re-emphasize that you will have the the training materials. So there will be items that you might see on your screen that I don't talk about. I've given myself a pretty strict timing on the agenda so that we can make it to all of the material. The slide that I have up today is just a reminder for attorneys only that if you are not already registered as a user of the Florida Dependency Law Center, floridadependencylaw.org, I encourage you to do that. We share information about trainings and events, other happenings, and there are a great deal of resources that are available for attorneys and judges on that website. That's one of the things that we do to train and support attorneys. So today we are going to be talking about what passed, what failed, and some exciting federal rules that have recently been enacted. And actually were enacted after we scheduled this training. So quick overview of the bills that we're going to be talking about in the what passed category. And I want to start by saying I am a children's rights attorney. My perspective on this legislation is from that perspective, how it affects children primarily. I care about the other parties in the dependency system, but I don't come from their perspective. So you may hear a similar presentation from another entity and get a different viewpoint of it. And that's fine and normal and natural. I just want you to understand where I'm coming from when I share the information that you're going to see. So if you have been to trainings in the past, you may have seen me jump off with a slide that had a train on it. There's a legislative concept that calls some bills a train. That bill is going to go through, so everything related gets piled onto it. This year, we didn't really have a train, but we did have what I would really call riders. So there's a bill trucking along, and it's going to pass, and somebody says, whoa, my bill's probably not going to pass, but I'm going to try to get it to go on. So the first bill we're talking about is a rider, House Bill 7089. House Bill 7089 was moving along as a bill about medical debt and transparency and bill collection and the healthcare industry. Much of that happens to be in Chapter 409. Chapter 409 of Florida statutes is where a lot of the CBC law is located. So as we are riding along, a bill about the CBC-DCF relationship, that language was put into 7089. I'm not going to talk about the medical debt provisions. We're going to talk about the CBC Child Welfare Agency provisions. So this comes from a concern that, and there's, I won't call it a pendulum, but there's a varying of opinions and dispositions as DCF secretaries change and governors change about the role of DCF and doing oversight for the community-based care lead agencies. And there are periods of time where DCF and the legislature want more oversight, or they identify things that are of specific concern that they feel the CBCs aren't doing the way they want to do. So that's when we see accountability bills like 7089. It talks about the procurement process that lead agencies have to go through. There was a lot of concern. Some of the lead agencies have additional businesses that are child welfare related that do some work in the child welfare arena. Not going to go into details to it. If it's of interest to you to look more into CBCs, then you want to look at 7089 on the lead agency procurement, how they can do their subcontracting. And this is something that I think every practicing attorney and people in the system need to know. When Florida privatized child welfare, they set a limit on how much of the direct work the lead agency could do. And that limitation is 35%. The idea being the other 65% of services should be provided by other community partners and entities. Some places have a difficult time with that. They can get an exemption. And so some additional details were put into this section of the law. The little red gavel on the bottom is my practice tip. I'll have those sprinkled throughout. If you don't know, the CBCs are required to publish information about some of their operations on their websites. So for example, if you want to know the average caseload for caseworkers, that is already required to be reported on their websites. It's in 409-988. This year, the legislature added additional details of what CBCs have to report. So if you're having issues in your community and you're wondering, is this just a one-off or is this a part of a broader systemic issue, take some time, go to the CBC's website. They put them under different names. Sometimes it's mandatory report, sometimes it's something else, but you should take a look. This is what the CBC is telling the world, that DCF is telling them they have to report on. A big issue, and I will call this inside baseball. If you're not interested or don't know the details of how the state decides how much money each CBC is going to get, gloss over this. But if you care, if you feel like your CBC is getting rooked or another CBC is getting too much money, there was a lot of attention given to the funding methodology. There was a proposed methodology that did not pass, but they're working on it and they've created a project to keep working on it. And so there will be going forward a work group to work on it. So again, inside baseball, if it's of interest to you, this is the bill you need to take a look at. The next item was a Florida Youth Shine priority, and I'm going to turn it over to Geori to discuss with you.
Thank you, Robin. So as I mentioned, Florida Youth Shine is Florida's Children's First youth-led advocacy organization. And every single year they pick a legislative topic that they want to work on that's most important to youth in care at that time. And what was really important that our young people were talking about for many years was the lack of resources available to those young people who turn 18, but were placed with relatives or non-relatives or were adopted as a teen. Florida puts a lot of resources into young people who turned 18 and licensed care for their journey to success, but not a lot of resources for those that didn't. So Florida Youth Shine really wanted to look at options available and work on a priority that would help those young people. They also had some issues with a couple years ago in 2021 when DCF received a lot of federal funds for COVID during an emergency that they weren't able to utilize those funds fully due to the legislation. So Florida Youth Shine wanted to tackle that legislation. Next slide. So they did that in the way of aftercare. So aftercare services are different from extended foster care or PES. What they offer are things like mentoring or tutoring, mental health services, substance abuse counseling, emergency financial assistance to overcome barriers to self-sufficiency, temporary financial assistance. There's a ton of different services and supports available through the aftercare program. But those, like I said, were not available to young people who did not age out of those from licensed care. So SB 564 passed. We are so excited. Florida Youth Shine spoke with over 100 legislators, and they work with Senator Garcia and Representative Tremont this year. And we're very excited to share that legislation was signed by the governor recently. So who is eligible for aftercare? So the same folks that were eligible before, young adults who were previously in foster care that are between 18 to 23. And now we're placed by the dependency court into out-of-home care for 6 months or more after the age of 14. And either they turned 18 when they were still in out-of-home care, meaning that they were placed with relatives or non-relatives, whether or not those individuals obtained a foster parent license, they were adopted, they were placed into a guardianship, or they were emancipated. Who is not eligible for aftercare. Unfortunately, and the original bill actually had this eligibility, and Youth Shine thought this is really important, but at the end of the day, it did not end up passing in that way. But young adults who were previously in the foster care system and were reunified with their parents before 18. So unfortunately, not that population. And those young adults who were in the foster care system but left before age 14 or without spending 6 months in out-of-home care. It also, as I mentioned, the COVID situation, it also authorizes DCF to distribute federal funds to all young adults deemed eligible by the funding source if there is a state or national emergency, so that if there's funds available, that these young people can get them.
Thank you, Geori. So the next bill we're going to talk about was titled Permanency for Children. House Bill 1083. And a lot of this bill is geared to moving things more quickly, trying to shorten the time in which things occur to get children to permanency faster. I will say, though, that many aspects of it are really more in the nature of housekeeping or updating things that are not so much geared toward permanency, but that needed to be taken care of in the statutes. So the first of those items is, get my clicker to click. Criminal history checks is really not anything new and exciting here, but Florida's law was not in compliance with what the FBI requires in order to be able to use the federal fingerprint checking system for criminal investigations. So there had to be some definitions put into the law to do the criminal history checks. And that did include adding a definition of visitor so that they would know who was required to be fingerprinted in order to do the fingerprint running. The next area is a new section of statutes, and I put my little stopwatch in the corner. This is a permanency related piece of legislation. It creates a new section of Florida in Chapter 39 that creates the procedure to follow if a child's parents are deceased. So it recognizes this in two regards. It could be kids in the community who have never had child welfare involvement, who it's believed that both of their parents are dead, and there is no process in place to get them a legal caregiver. And it also recognizes that sometimes for children who are in open cases, their parents may die and there needs to be a process. So yes, the department has been handling these things, but they kind of had to make an assertion that the child was abandoned, but they weren't really abandoned, the parent died. So this section of the statute creates that process to handle the situation with children whose parents are deceased. It recognizes people might be wrong. So there has a full process that has to be followed. Who has to receive notice? There is required to have an evidentiary hearing and a decision by clear and convincing evidence, not evidences, that both parents are dead. If they're deceased, the department has to adjudicate them dependent and permanently commit them, I hate that term, to the custody of DCF. If there's not a preponderance of evidence that they're dead, but they're not available, then they're adjudicated dependent. And if neither of those are true, the petition is dismissed. The next area of law, I will say, that was changed, and I'll put this more in the administrative category, is post-disposition change of custody. So this is what's happening when the child has been sheltered, they were adjudicated dependent, they have been placed into custody of a foster parent or which is in the custody of the state, or the custody of a relative or non-relative, which is not in DCF's custody, but still under the care of the state. So if they're in a foster home and they've been placed in a foster home and there is an allegation or assertion that the child needs to be moved in an emergency fashion, there isn't currently a process for that. The reason there's not currently a process for that is that the law used to say DCF could just come in. If they're in licensed care, they can just pluck them out of licensed care and move them to another licensed care place. A few years ago, 39-522 was changed in a way to be protective of children and the people that were caring for them, to say, whoa, you can't just on your own pluck them from one place and move them to the other. There are some presumptions attached if children have been in a home for a long time, if they are on a path to TPR and the person is a prospective adoptive parent, and there's protections for children so that they're not transferred willy-nilly, that there's notice and a process. So when the law was changed to protect children and some caregivers, it didn't put in a provision for what to do if something went wrong. So DCF was having to use a shelter petition, but it was kind of weird because the kid already was sheltered from their parents. So this creates a process for emergency removal that parallels the shelter process, requiring probable cause to shelter, but it requires hearings in the follow-up. If the assertions that were made about why it wasn't safe and appropriate for the child to remain are not founded, the child can be returned to the caregiver's home that they were removed from. And I put in here my practice tip, which is, even though this provision is coming into effect, it doesn't change the requirement that children have a right to a transition plan. If they're supposed to have a transition plan 10 days at least before they're moved. If there's an emergency and they have to be moved, there's still a requirement for a transition plan, and that is supposed to happen within 72 hours after the move. So if you're working with kids and they're all aflutter because of what happened, get that transition plan going. That is the right of the child. The next area of law that was changed relates to the permanent guardianship that are entered in Chapter 39. And this was also kind of a timing to permanency thing. So what this section of the law addresses is a child is placed into the permanent guardianship of someone. Hopefully, at the outset, that guardian has designated a standby guardian. So if something happens to me, my sister's going to take care of the children, and we should all have that for our children, right? So in this circumstance where the guardian has identified a successor guardian, and that person is named in the original guardianship agreement, they will no longer have to wait 6 months before the successor guardianship can be finalized. That time was cut down to 3 months if the child knew the successor guardian. So this is my mom's best friend. This is my aunt who lives, in town that I see. The guardianship can be entered in that 3 months. If it's, this is my best friend from childhood who lives across the country that my kid never knew, they're going to get the whole 6 months to make sure that the relationship is appropriate before it finalizes. There were some other changes, and I put my heart here because they really benefit children, and they kind of go in parallel to the aftercare changes that Geori talked about. So right now, for young people who are put into guardianship or adopted after the age of 16, the state can either continue the adoption assistance payments or the guardianship assistant payment, or offer post-secondary education supports and services and supports, PES, to those young people. That cutoff age under the current law is at age 16. What this law does is move that back to 14. So if that guardianship is closed after the child turns 14, the assistance payments can extend to the age of 21. Likewise, those young people who hadn't been eligible for PES will now be eligible for PES. So hopefully you already have in your mind, when your kids you're working with are getting close to 16, we need to wait and check and see what's happening before, don't rush to close the guardianship a week before they turn 16. Now you need to be thinking in your head, it's age 14. So don't do it at 13 and a half. If you can wait the 6 months at 14, that will extend both the assistance payments and Medicaid, because Medicaid for these children, when their case is closed prior to 18, Medicaid ends, adoption-related Medicaid ends at 18, and guardianship Medicaid, unless there's an extension of those subsidy payments. So going along with the extra payments is the access to Medicaid. That's a big chunk of support that families are being families are being offered. Next item. This is parents' attorneys. This is one you want to pay attention to. This has to do with service of process for a termination of parental rights. The current law says if the parent is in the TPR advisory hearing, they are given notice of the date of the TPR hearing. Now we have parents that are at the TPR hearing, but they're appearing electronically. So they have the same information, but the process serving aspect didn't catch up to it. So this says if they were appeared at the hearing by any means, then that is given notice, because what they've had happen is parents are there electronically and then they have difficulties serving them with the actual physical process. So this is catching up to that. Okay. I'm going to take a quick look because I've been steaming through and I think I'm okay on time. I think these questions are a little more about kind of more case specific. And I will try to talk to you guys about them afterwards and like the thinking behind the law. That will save. I want to make sure that I'm explaining the law in a way that's clear what the intention and effect are. Okay, next one. Post disposition relief, petition for adoption, consent. Again, this is very much a time to permanency issue. If you are an adoption attorney, if you are a family law practitioner that does some adoptions once in a while, if you work with caregivers who are trying to adopt, you need to pay attention to this. So the current process is if the CBC and the department deny your petition to adopt, or there are multiple competing petitions to adopt the same child, those issues go to something called the Adoption Applicant Application Review Committee, ARCs. You probably heard of ARC. If the ARC decides against you, under the current process, you have the opportunity to seek an administrative hearing under Chapter 120 of Florida statutes. That administrative hearing includes aspects of due process like discovery under the rules of civil procedure. Then, depending on how that turns out, you may also then be able to put the very similar issues in front of the judge. So what is happening in this change of the law is that the opportunity to take adoption application decisions to the Chapter 120 hearing has been removed. When the law goes into effect on July 1, you will not be able to take a 120 hearing. What will happen is after you receive the notice that you were denied, you will have the opportunity to take that issue to the dependency judge for review. So the process is specified very clearly in the law about the number of business days that you have to file your petition for the court to hold the hearing on it. The law creates standing for denied applicants solely for the purpose of making the motion and presenting evidence, and it specifies that standing ends on the entry of the court order. For non-lawyers, standing means the legal ability to be in front of the judge to have your issue heard. The law also says that the approved applicant, so, we have Smith and Jones are both trying to adopt the child. Smith is approved, Jones is denied. Jones has the right to seek a hearing. Smith has the right to participate in that hearing as a participant, and they don't have to seek leave to be heard on a motion to intervene. I'm looking real quickly at Jessica's question about what happens with the 120 hearings. I don't know. That is a good fair game question, and I'm sorry, I don't know if anybody knows the answer to it. If they do, feel free to put it in chat. But it's a very good question. So when the judge is making their decision, the standard of review is called abuse of discretion. Again, for non-lawyers, this is a very low standard of review. So, if you think about criminal, beyond a reasonable doubt is the highest. Clear and convincing comes right under that. And abuse of discretion, pretty low. There's also only two things that the judge can consider in this hearing. One is is the denial consistent with DCF's policies? And the second is whether they made the decision in an expeditious manner. So what I've put in here with my little practice tip is that there are some adoption attorneys who have been challenging the policies that DCF applies when they're making those decisions. So the specific citation is to a case where DCF relied on what they call a kinship rule in the DCF Administrative Procedures Code. And the hearing officer found that DCF did not properly adopt that rule, that it was an invalid delegation of legislative authority. That's a whole nother training for a whole nother hour and a half. If the basis of the decision that you're challenging is a policy, there is an outstanding issue about whether that policy is valid. Now, I don't think you can challenge that well, I'm not gonna assert. This is an issue that will be litigated. Let me just put it that way. So the next issue is, well, how do you get things together for the hearing? So the law does not use the word discovery. The current process provides for discovery. And so I would assert that if you have to convince a judge that DCF complied with its policies in making the decision, A, you need to know what the policies are, and B, you need to know why they decided what they did. And if you don't already have that information, I think due process compels that you have the right to get that information. So there are specific documents that are produced in relationship to the Adoption Application Review Committee, and there are people who are expert in handling those. And it is, in some ways, will probably make things go more quickly, and there will definitely be litigation when there's disagreement. So and the next question is then what happens if the court says, yeah, you know what, you're right, DCF didn't follow its own policies, or it wasn't expeditious. If that's the case, then the court then gives the denied applicant the permission to file a petition to adopt. And then in that case, the court has competing petitions to adopt. So the motion that is made is not a comparison between two families. It is just whether one person's petition was unreasonably denied. So it can lead to the situation where there are multiple denied applicants. And thank you for answering, Rosemary. I know Rosemary is the expert in this area, and I appreciate her weighing in on it. There's going to be a lot of discussion about that aspect of adoption. Switching to another gear, and it's timing and also a little bit of procedural cleanup. So currently, to do an adoption, you have to have an adoption home study. Some people are caregivers to children based on a foster parent licensing home study, or a home study that was made for a relative caregiver before the child was placed in the home. So they have a current active home study that is not entitled an adoption home study. So this change in the law, and again, this is in Chapter 63, permits the agency to use a current placement or licensing home study in the place of an adoption home study. And I think there probably could be a very interesting discussion about the costs and benefits of that, and timing to permanency, and whether they're actually equivalent and what is lost because they're not equivalent. And then I put in my spotted dog, totally separate issue. But again, there's a big urgent need on the part of the legislature to move things more quickly. And somebody knows somebody who was in the military who did their adoption training and pre-work in another state and had to do it all over again when they moved to Florida. So there's a provision that says DCF, don't make people duplicate things, including, but not limited to, people who are members of the uniformed military. So, but it's not limited to that. So if there are other things that you want to assert are duplicative or unreasonable delays, you can raise this section of the statute to say, don't put my family through this. Like, let's move it along. Okay. This is really targeted at adoption agencies and entities. So lawyers are permitted to be adoption entities without having an agency license to be an adoption agency. There is a lot of detail and changes that were made to the statute about what fees they can charge, and now requires them to report quarterly to DCF information about the demographics of the kids that were adopted and the fees that they charge, and requires DCF to put some reports on its website. Again, this details will be of interest to, especially to attorneys and adoption agencies. If you do any of them, you need to follow this provision of the law. It also increases the adoption benefit. And no, Donna, the adoption home study, I do not believe is required before the adoption. I think the law permits the other type of home study to take the place of an adoption home study. The adoption benefits have increased. You know, we've changed the name from, oh, I forget what our previous term was. We're calling them difficult to place children. Benefits increased, and it added additional employees to, or folks who are eligible to take advantage of these one-time adoption credits. And there's some changes to the adoption exchange. This was, pardon me, this was really promoted by young people in another youth organization who didn't like their faces being spread all over the place and letting everybody know that they needed to be adopted. And so it's limiting the photo listings to people who are already in the process. You can't just go like browse for children the way you can for clothing now. And it also, it doesn't go as far as the young people wanted. They wanted to be able to refuse to have a photo placed on the website, but it requires them to be consulted about the listing, and they can ask that a specific picture is used in their place. So very, you know, that is kid-friendly provision of that statute. This is a new bill. So I'm gonna take a quick second and look and see if there's anything that I can answer. I think, are we all caught up? So Jessica's question about, will standards for caregiver home study change? That is a good question for DCF to answer. You know, because we know that people can be approved to take care of a child that have disqualifying events that don't permit them to adopt the child. So I'm not sure what's going to happen about that. And that is a great question for DCF to answer. Okay, so this bill, I think, actually went to the governor this week. So when I prepared the slides, it had not been sent to the governor yet. So presuming that it is signed, it will be effective on July 1st. There were a few surrendered baby bills. This is the one that passed. It increases the age of the child up to 30 days where a person can surrender. It allows the parent to surrender at the hospital. Now, they can't just walk away from their baby. They have to tell the hospital staff, I'm surrendering my child, something to that effect. It also allows them to call 911. If they can't get to a fire station or to a hospital, they can ask an EMT to meet them to surrender the infant. Okay, this is another writer. This writer, I went in the opposite direction because it was a bill that was a child welfare bill that then just got some things added on to the end that are related enough to be related. So this is the Dependent Children Bill, SB 1224. So what was added on relates to domestic violence investigations. This is not my area, but the main thing that it's done here is it's requiring law enforcement to administer lethality assessments if the allegation is against an intimate partner. And then there are specific things they're supposed to do depending on what that lethality assessment comes back with. If this is an area that you're interested in or work in, I urge you to take a look at this bill. The next kind of exciting thing for kids that's in 1224 is a new statute that creates prosperity grants to help young people move on, former foster youth coming out of the foster care system, who need a little extra financial assistance or help getting financial literacy as they're becoming adults, test preparation so they can take college admission tests, and assistance to help them in trades and careers. And I really like the fact that this grant is eligible, the youth remain eligible for the grant for a year after reunification. So it doesn't cut off right then. Karen, I see your question about lethality assessment. The statute requires the creation of one that FDLE is supposed to do with a bunch of partners to create it. And then there's provisions about training law enforcement. So what they're planning to use does not exist yet. So question. Okay. Next aspect of 1224, now this is a long bill and there are different pieces that do different things. So there is a running theme through the bill about connecting young people with supportive adults. This is key to the success of young people, is having at least one person in the world that they can rely on as a support in whatever form or fashion that is. So it is, the bill changes the purpose section of chapter 39. I will take the question in just a second. The person who it asks the system to recognize that connections with a supportive adult should be part of the overarching goal of chapter 39. Of course, we want that to be the parent if we can get the kid home. But if it can't be a parent, then it should be someone else in the child's life. And they also put it into the goals for dependent children. And then there are a variety of places where it pops up in statutes. So case plan tasks talk about developing relationships, coping skills, and emotional well-being. So that's part of it. It creates a new section of statutes, 396036, that puts an obligation on the statewide guardian ad litem office to help children connect with supportive adults. And if the teen doesn't already have someone in their life, the ESCALO will work with the child to identify a supportive adult. And that adult, there's a requirement for the young person and the supportive adult to enter a formal agreement for ongoing relationship. I'm not sure what that's going to look like, but there will be some documented agreement that appears in the child's court file. In addition to the guardian ad litem, statewide guardian ad litem office, the Office of Continuing Care also has a role in helping connect young people to adults if they don't already have one in their lives. It changes some of the other statutes related to supportive adults, and that's in the applicable, the court's inquiry at judicial reviews for youth who are 18 and older, and puts an obligation on the Office of Continuing Care, which is an office within the Department of Children and Families, to assist those young people. So I want to back up because there's a question about, does the party withstanding get to engage in discovery? And I think I addressed it. So the statute does not answer that question. My personal perspective is that the issues that are at stake are of constitutional magnitude, and that due process requires the ability to take discovery. That I don't think is the position of the department. And I imagine that there will be a lot of discussion and debate and potentially litigation about that issue. So it's a good question. So the I can't answer your question about medically training a parent. It's just not something that that I know the answer to. So, okay, so let's keep trucking into Senate Bill 1224. So, a rose by any other name would smell just as sweet. So we have two name changes that are occurring here. One is what we've called for years the Guardian Ad Litem program is now officially called the statewide Guardian Ad Litem office. And so a good chunk of this very, very long bill is sections of statute that just say Guardian Ad Litem program are now switched to Guardian Ad Litem office. So that's a big chunk of the pages of that bill. Everywhere has been changed. The other thing that has changed is that children's attorneys or attorney for the child are now almost uniformly called attorneys ad litem. The section of the statute that provides for counsel for dependent children with special needs is unchanged. It doesn't use the ad litem term, but essentially a kid's attorney is attorney ad litem. And so throughout the statute, except for that one provision, it's been changed to attorney ad litem. So hopefully this will reduce or eliminate confusion that, when a child has an attorney, some people call it attorney ad litem, some don't. The statute's now in most places called attorney ad litem. The other thing that's happened throughout the statute is you will find many, many places where the law would say the guardian ad litem, comma, if appointed, and other places that sometimes referred to that with the attorney ad litem and sometimes didn't. So uniformly across the chapter 39, it has been changed to remove the modifier if appointed. And so everywhere it will just say guardian ad litem, or statewide, we will say guardian ad litem. And the modifier if appointed has been added after the word attorney ad litem, the term. So that is throughout the statutes. The bill defines attorney ad litem, and there's not a current definition in Florida statute. So the term has been defined in the definition section 39.01. It is now subsection 8, and it specifies, hopefully what everybody already knew, that an attorney ad litem represents the child within an attorney-client relationship under the rules regulating the Florida bar. We're lawyers, we follow the rules regulating the Florida bar. So the guardian ad litem definition is located in, you're not seeing my whole screen because I put this really cool graphic on here that I don't know if you can see it. I don't know if you guys see the little sun in the corner. Oh no, sun's on the next one. Talking to myself. Guardian ad litem definition currently is in 39.820 and has been moved to the definition section of 39.01. I put the new definition on the left-hand side, the current definition on the right-hand side. So they're not identical, but they are substantially similar in the key aspects about the current definition says they represent the best interests of the child. The new definition says they use a best interest standard in doing their decision-making and advocacy. Both of them acknowledge that the guardian ad litem is a party to any judicial proceeding as a representative of the child. The new definition uses the term fiduciary, which the Escalo has been using for the last couple of years. And as they stated when they sought to have this bill passed, they were seeking to codify their existing practices. So it's new in the statute, but it's not new in relation to the guardian ad litem's own program operations manual, or I don't get the term straight. So not a new concept, but it is new language in the statutes. So there's my little sun you can see in the top. I guess I gave it to you twice. I put the sun in to say there's nothing new under the sun. You've already seen the two pieces of the statute. On these slides, I've put the delta symbol, which I think is the chemical symbol for change. So this is a really significant change in Florida statute. the appointment of a guardian ad litem is mandatory for all children. Current statutes permit the court to appoint at its discretion. And, for a long time, the local guardian ad litem offices and the program, when it was a statewide program, didn't have the capacity to represent all children. And so that discretion remained. So the statute has now changed and the appointment is mandatory. And that's been made clear in the sections of statute that are listed on this slide. What has also been changed, very significant change in statute anyway, is it specifies that a guardian ad litem can represent a child in proceedings outside of the dependency case. And this has been, and to do so to get services and benefits for the child. So this has been a kind of a back and forth within practice in different parts of the state in different times over the last, I would say, 20 years. So this is making it clear that the guardian ad litem can represent the child outside of the dependency court. So I've given an example of what some of those things might be. Fair hearings, Social Security appeals, school cases like due process or school discipline. So if there was a previous perception or requirement that the advocacy was limited to the Chapter 39 case, the statute has made it clear that that is no longer the situation. Okay. I'm just checking my time to make sure we are trucking along. All right. Next part. Okay. Chapter 39.822, which is the guardian ad litem section, specifies the fiduciary language that was in the definition. They are a fiduciary and they must provide independent representation using a best interest standard. And independent here means independent of DCF. DCF makes its decisions. The guardian ad litem makes its own decisions about what will happen with the child. So the advocacy tip here is find out the factual basis of the S. Gallo position if it is a mirror to DCF's position and it's not in your favor, right? So you have, if you have an opposing position to DCF and the S. Gallo shares in that position, they are supposed to have arrived at that independently. So it's not just we're going to agree with DCF, right? They have to come to their own independent conclusion. And so that is a fair game for you as an advocate to seek the evidence on to determine whether they have a basis to make the decision that they're making. Guardian ad litem responsibilities currently are in the TPR statute. And this is it's a little more truncated. So they have created a new section in 39.822 that collects up those duties and responsibilities and puts them in one place for all proceedings. So it's not limited to TPR. It is for how the guardian ad litem, what they are supposed to do. This is the individual guardian ad litem's responsibilities. And I put a heart next to advocating for the child's participation in the proceedings, reporting their preferences to the court. So just super important from the kid's perspective that that they have a chance to participate, know what's going on, and be part of their proceedings. Okay, access to the child. This might have been a question I saw scrolling through. I'm going to say nothing new under the sun because the guardian ad litem and the child's attorney currently have access under 39.4085. So it is restated in 39.822 a new language that they have immediate access to the child. So this has already been an issue that has come up with colleagues around the state. So I put in the practice tip here that the rules of professional conduct have not changed, and they apply to attorneys who work for the statewide guardian ad litem office. And I've just referenced two of the rules that may come into play in this circumstance. And so, I attorneys at the guardian ad litem program are now speaking to children directly. And so these rules of professional conduct may come into play. Not the subject for this training, but something to keep a lookout for. Okay, again, there were changes to what the office is required to do, the statewide guardian ad litem office. And so part of it, nothing new under the sun. This slide is the existing requirements for the guardian ad litem office and what they are supposed to do, and is unchanged from current law. What has changed is the subsection that requires the SGALO to make sure that each child has an attorney assigned to their case and is using it to the extent that they have the ability to, a multidisciplinary team. So this is the SGALO office itself ensuring that one of its attorneys is assigned to every case. This is not a requirement that the SGALO find an attorney outside of guardian ad litem to represent the child. This is within the SGALO office. Although I have noted here that they can't be on every case because there may be a conflict of interest. So if you're working with a child who the SGALO had to withdraw because of a conflict, you should be asking the court to appoint an alternative, someone outside, and the guardian ad litem may do that as well. The child should have a person representing them if the office itself has a conflict. The other new aspect of this law is that it provides for the SGALO to do oversight and technical assistance. Oversight and technical assistance was already in the law. The specifics of creating an attorney ad litem training program, consulting with chief judges and maintaining registries, and helping recruit, train, and mentor attorneys, those are new things that were added. So this is just it's a hugely important arena because, we have a lot of children who are entitled to the appointment of counsel under the Counsel for Children with Special Needs. And not every area of the state has a sufficient number of attorneys. And local judges don't have additional resources in creating and maintaining the registry. So this is putting an obligation on the SGALO to help make sure that every part of the state has an adequate number of attorneys who are well-trained and appropriately suited to represent children. This is not authority for the SGALO to provide oversight in a particular case, to review what its specific attorney is doing in a case. It does not do that at all. This is a general provide support and assist the court obligation. Okay, I'm going to stop here briefly. I'm going to check my time, and I am a little behind. I'm going to hold questions until the end because I'm a little behind of where I want to be. So the next area of law, super excited about, whole brand new law, supported decision making. And this is for not just young people, but for adults who have difficulties in their decision-making capacity, and it provides a new tool to use with them so that people don't have to take away their rights to make decisions in order to help them be safe and protected and self-actualized. So it's actually a form of power of attorney, a new form of power of attorney. I'm not going to go into details. Happy to talk with people offline. I'm sure the folks at Disability Rights Florida would love to tell you about this. It's a really important innovation for our young people. And the practice tip here is when you're doing a Regis Little staffing and the judicial reviews about decision-making, keep supported decision-making in mind. It's a great new tool for people to use. And not going to go through the statutes. Oh boy, holy cow. This Juvenile Justice Bill 1181 is really long. I'm showing you, I showed you a rose about the name change with SGALO. I think it's stinky that they want to change civil citation to pre-arrest delinquency citation. That's done throughout the bill. And there are a number of provisions on that. I'm going to speed through this one. This bill, a lot of this bill was about kids and firearms and holding them more accountable if they use firearms. So there are a number of firearm provisions in 1181. It also is about holding children longer than they are permitted to hold them now in a variety of ways at detention intake, doing more electronic monitoring, exceeding the time for that kids can be held. I know some of you are very interested in this, but probably not the majority of the folks that are on today. So kind of skipping through them, but it is geared at holding kids more accountable. This one provision, I think merits taking a little closer look at. It creates a new graduated response matrix. And it's the idea that when a kid has violated their probation, the sanction should reflect the violation and not, I think, not be a one size fits all, but really be meaningful to what the child actually did. So it is going to be created, and those that work in this arena, you should pay close attention to this. This is putting a little duty on the state attorney to explain why the heck you're not filing a violation. But again, it's all a push for accountability. It permits kids to retain their license for going to work. I think that's a good thing. Puts more conditions on conditional release, lets them use the dogs to go look for contraband and commitment programs, and essentially waives your FERPA, your educational privacy rights, so that your educational documents can be used in juvenile justice proceedings without your permission or your parents' permission. Okay, next new bill, online access to harmful materials. This got a ton of media attention. Got the number, House Bill 3. This affects all kids, social media platforms. I have put the high level details in these slides, which again, you will get after the presentation when you get the Zoom link. Encourage you to take a look at, if you haven't already read all about it in the media. So the next one, again, employment and curfew of minors. This was not a kid promoting bill. It was, maybe if kids need to work more, it's a kid promoting bill, but the details of the extension of time that kids can work are in this change to Florida law. And okay, interception of communications. So Florida started, we start with this baseline that you cannot record somebody without their knowledge. Florida is a two-party consent state. So if you're yelling at me, I can't turn on my phone to just record what you're saying to me. They had started with an exception based on the person themselves. And now this year, the exception was expanded to the parent or guardian of a child can intercept and record a communication. And I think last year's was maybe domestic violence related. And I'm not sure it's last year, the previous one. So it's an expansion giving parents the ability to record when they think their children are being injured or at risk. Okay. I've given you several slides of the bills that failed. I'm not going to spend time going through them, but I include them because the bills that failed this year are likely to come up again next year. Some of them may come up for several years and never make it, but oftentimes ideas take 2 or 3 years before they percolate to the top. And so I've included all of these specific bills in case you want to take a look at, what are they talking about? So I'm flying right through them, all the bills. Okay, so I flew through things, excuse me, because I wanted to be sure that we could add on a look at the federal rules. So this does not happen often, but this past fall, there were 3 significant rules that the federal government put out, what they call a Notice of Proposed Rulemaking, NPRM. I had not dealt with them before. I'm used to how DCF does their rulemaking and a little bit of APD. The federal Notice of Proposed Rulemaking is fascinating. The documents are very long. They have a great deal of background, a great deal of explanation as to the issues that they're trying to address, that uh, current decisions that have been made or other policies that they can reference. They're very, very long. And then they invite public comment. Some of these rules had hundreds and others had thousands of public comments. So they take those comments, and when they issue the final rule, the rule itself could be really short, but the document is really long. So they include information about the background, and then they go through the comments, and they clump them by topic, but they explain, this is what people said to us, and we agree, but we think it's already addressed in this way, or we hear what you're saying, but we think we're fine the way it is. Or occasionally they'll say, you're right, and we need to change our language, and we made this specific change. So a great deal of the information about the intention of these agencies is found in the notice of the final rule, not in the language of the rule itself. So you really have to, if it's an issue of interest to you, you really have to spend time with this really significant document. So there were 3 rules that really impact kids and child welfare system that I'm going to talk about today. The first one is the foster care legal representation rule. And the rule was issued earlier this month. It will become effective on July 9th. And I've cited the code provision. Once again, you will get all of this in the PDF. All right. So the overarching goal of this rule is to promote family well-being and time to permanency by promoting the states to support parties in the child welfare system to have high quality legal representation. And the goal is, and data shows, everybody is better off when all parties have high quality legal representation. So the discussion in the background can be very interesting to folks. It's about stabilizing families, not bringing in kids that don't need to be brought in, and getting to good resolutions more quickly. So it has, boy, this is like gobbledygook if you don't work in the arena. It's 4E reimbursement for legal representation. 4E is a title of the Social Security Act, the same Social Security Act that pays disability benefits and SSI benefits. Title 4 of the Social Security Act is the main funding source for a lot of child welfare. Title 4B to a smaller extent, and Title 4E to a greater extent. So you may hear Title 4E when kids are in foster care. Florida gets a reimbursement for about half of the cost of foster care. It gets a 4E reimbursement for what it spends to provide caseworkers. It has for a long time gotten a 4E reimbursement for the attorneys that represent DCF Children's Legal Services, DCF CLS. For a long time, it was limited to attorneys for the department to get that federal reimbursement. But in 2019, the Children's Bureau, which is the relevant entity in the government agency being the Agency for Children and Families, ACF, said, hey, it's really helpful when kids and parents have high quality representation. We're going to start reimbursing for it. So they did that by changing their policy manual in 2019. And what it provides for is that DCF can get 50 cents for every dollar spent on representation. DCF doesn't get to keep that money, keeps the money for its own attorneys, but it passes it through to the entity that's funding that representation. It's not exactly 50 cents on the dollar because some children are not eligible for 4E, and that's a whole nother lecture. But that's the rate basis. It comes out quite a bit less than that. Okay, so what parties are covered? Who can the state submit reimbursement for? So the rule now says independent legal representation by an attorney for, so it's for children who are in foster care, and they have to be 4E eligible, children who are candidates for foster care. Now, this, people have been talking and should be talking about candidacy for foster care when we talk about it in the prevention context of who is eligible for those evidence-based prevention services. That definition of candidate is much broader than this definition of candidate. So unfortunately, we're stuck with a narrow definition of candidates of children who are candidates for foster care. It has to be if DCF is planning to remove or making reasonable efforts so that they don't have to remove the child. So it is also then eligible for the parents of such children. So there's a movement around the state for early parent representation. So if we can get parents the help they need before their children are sheltered, we can keep families together and keep kids out of care. To the extent that those parents that are being helped have children who are candidates for foster care, then reimbursement is available for that. And it's definitely available for parents of kids whose children are in state care if the child is 4E eligible. Interestingly, the reimbursement is available for relative caregivers of these children. And Florida is not doing that right now, but it's an area where we could expand. And then for kids that are subject to the jurisdiction of Indian tribes, there's a term they have created or used called an Indian custodian. So it's not necessarily the parent or a legal guardian, but it's the person who is taking care of that child would be eligible for the reimbursement. Okay, so what proceedings can you get the money for? Well, clearly foster care proceedings. Once your Chapter 39 is open, what the attorney does in the Chapter 39 case, that work is reimbursable. The exciting thing about this is that it also talks about civil legal proceedings that are necessary to carry out the requirements of the 4E foster care plan. So what does that mean? Well, unfortunately, if we're talking about immigrant children and parents, immigrant children are not covered because they have to already be a citizen or a qualified immigrant in order to be eligible for 4E. But if a parent is an immigrant and the parent needs legal assistance for a 4E eligible child, so maybe the child was born in the US, but the parent needs help handling a landlord-tenant issue so they don't get evicted, so they have a home, then the parent, immigrant parent, can be represented in that situation. So housing, preventing eviction, stabilizing housing, if those are things that are necessary to carry out the 4E plan, right? We're going to make reasonable efforts to not have to take this kid into care, then that civil legal assistance can be provided and eligible for reimbursement. Likewise, for public benefits, this family could get income if the people got access to SSI or other disability benefits or other benefits. That public benefit work, legal work, could be reimbursable. I think there's a little more question about family law matters like custody determinations or domestic violence injunctions. I don't think there's a clear answer on that yet. Okay, what expenses are covered? It's the attorney who's doing the legal representation, and not just in court work, but facilitating and doing other things outside of court to promote the child's case plan, and professionals that support those attorneys. Super exciting. Peer investigators, paralegals, social workers, and other professionals. So it remains to be determined what that could be. Super exciting. So what is independent legal representation by an attorney? This is a question that's come up a lot in Florida. And the comments section of the rule, again, the language of the rule is really short. The information and the guts of it come before the rule. And so this statement was made to clarify independent means not subject to the control or influence by other parties interested persons, or the 4E agency. And then the rule also gives some other suggested but not required expectations. So the decision about whether the representation that's seeking to be reimbursed qualifies is made by the 4E agency, which in Florida is DCF. And the rules make it clear that they are not requiring the state entity, and the federal government itself is not taking on the regulation of attorneys. That is not the intent, to regulate attorney practice. Okay, so that is the first very exciting rule. Second very exciting rule, designated placement requirements for LGBTQI+ children. This came out at the end of April. It is the effective date, if you look, is October 1, 2026. This rule has received a lot of national attention and public scrutiny. The goal of the rule is to make sure that all of the kids in care are free from harassment and abuse, and all of the kids. So, it was originally just written for LGBTQ kids, and of course, every kid should be free from harassment. So they have come up with this new term of designated placement. Let me start by saying what they use the term LGBTQI to include. They made an acronym, but asserted that it is a very broad umbrella and incorporates a lot of young people. So the designated placement requirement in October 1 of 2026, this will be a requirement on DCF and the CBC lead agencies and their subcontracted providers. They will have to have safe and appropriate placements for all children in care. Duh, they should be doing that right now. And that means free from harassment, maltreatment, and abuse. And they should have designated placements for LGBTQI+ children who ask for them or who would benefit from them. The rule is clear that no provider is required to become a designated placement. There was a lot of comments that said every placement should be safe and appropriate for all kids, and that was not taken up. There's not a requirement for any particular caregiver or provider to do that. The requirements are to commit to support the children, their status, their identity, to accept and take the training that's necessary to be able to address and promote them in their self-actualized being, and to give access to young people to the resources that they need. It has a process, and this is still very concerning and tricky for young people, of like, who do I have to come out to, or why do I have to request, and will my information be kept privately? And there is an attempt to direct the states on how to handle that to protect children so that they have access to what they need without exposing themselves to additional harm. It also requires that the state, DCF, the lead agency, give substantial weight to what the child's requests and concerns are. And this means that if a trans child requests to be placed in a placement that is limited to people of the gender that they weren't born to, that the state should give substantial weight to their request. It also requires that before moving a child, that a consideration is given to whether services and support could be put into place that would help the young person stay where they are without having to move. It sets a requirement for the state to create a process for young people to report their concerns, that their placement's not meeting their needs, or that they're being retaliated against, and has some specific requirements for that process. It has the states protect children against retaliation. This is going to be very challenging, but it's worth the endeavor to try. It defines retaliation and talks about giving access to services that are developmentally appropriate. It's not, we don't just wait till someone's 14 and then decide they're old enough to have access to services supporting their sexual orientation, gender identity, and expression. It can be younger if it's developmentally appropriate and requested. Am I going the wrong direction? Okay, so specifically requires the offer of placement consistent with gender identity and the ability to voice concerns like, I really like my Aunt Betty. She's awesome, but she doesn't support me and who I am. And I will have to hide who I am and my identity if I live with her. So I would prefer not to live with Aunt Betty. I love her. She's my aunt, but I don't want to live there. Has training requirements and specifically talks about the religious freedom of people who don't necessarily agree with the perspectives that are being promoted in the rule. Okay, last one, the parents with disabilities. This is section 504 of the Rehabilitation Act. You probably have heard of 504 plans. We use them for kids for educational purposes. They're reasonable accommodations for people with disabilities, and they are required in programs that are federally funded. So this was a very lengthy rule. They did a specific section, they added to an existing section to talk about children, parents, etc., in the child welfare system. It explicitly precludes discrimination on the basis of disability within the child welfare system. It applies to DCF, the CBCs, and all of the subcontractors. The goals here are to prevent discrimination based on speculation, generalizations, stereotype. Every decision should be made specifically about the person, not just they have cerebral palsy, they can't possibly parent a child, right? It has to look at each individual, and it specifies these things, which are discrimination if they occur to a person with disability. And I've put a heart next to that last one. States cannot require children with disabilities to live away from their home in order to get services. How many times have we worked with families who are told this child needs residential placement, but you're going to have to surrender your rights to get it? That is a violation of this disability provision. This parent attorneys, super important. Evaluations need to be looking at the actual parenting ability, not just a quick IQ, and it should be done by somebody who knows what they're doing, who can determine what the parent's strengths and weaknesses are and evaluate the parent, who they are, not just, again, by the label. All assessments have to be individualized, not just the parents, but also the children, and the supports that a parent might need to safely care for their child are both the natural supports who they already have in their life, and it can be paid support. If the caregiver does not have physical use of their arms, their personal care attendant, their paid support, should be considered part of the determination of their individualized assessment. Okay, there are additional information from the comments. Again, most integrated setting, that's a bottom line thing for kids and people with disabilities. And okay, so I have plowed you all through, and we have, I think, looks like 7 minutes to look at. I'm going to turn off the screen sharing and try to take a look. Alexis and Geori, have you seen any of the questions that you think should go top of the list to get answered?
Thank you, Robin. Geori, I'll turn that to you since you're more familiar with the subject matter. And while you're filtering through and looking at those questions, would you like me to announce the CLE code at least while you're getting through that?
Sure, go ahead and do that.
Awesome. So folks, the CLE code, I'm going to pop it into the chat. I just popped it in. It is 2404450, N as in Nancy. Again, 2404450. 1.50, N as in Nancy, and this was approved by the Florida Bar for 1.5 general CLE credits and 1.5 juvenile law certification credits. Anybody who needs a certificate of attendance in addition to this, you can email me directly. I'll drop my email into the chat again, although it is up at the top. Enough of the logistics, turning it back over to the substance. Geori, Robin, have you decided any questions you'd like to pick out?
I'm
Sure.
sending Robin some directly so that she
Yeah.
can pick them.
Okay.
Perfect, thank you.
So the question I think was posted, can the statewide guardian ad litem office have access to records on cases to which they are not appointed or have a guardian ad litem assigned? No and yes. They have to be appointed to the case. So this, the law requires the judge to appoint, but it doesn't make a blanket presumption that they are appointed on every case. And as we know, there could be conflicts or other reasons why they can't be on a particular case. So when the office, when there's an appointment, then they have access to the records. Until there's an appointment, they do not have access. If the guardian ad litem is required, when can they be excused by the court? The law does not specify that. And, I think that will be handled in the individual court. I hope that everyone who is participating in this will make sure that if they're aware of a child for whom the guardian ad litem is not on the case, that they have some other form of representation, that they have an attorney or that they have a guardian ad litem outside of the statewide guardian ad litem office. There certainly have always been cases where there's been a conflict or other people, the statute for appointment has always given the court the ability to appoint people outside of the guardian ad litem office to serve as a child's guardian ad litem. So make sure they're not completely unrepresented if the statewide guardian ad litem office is actually not on the case. Okay, I am worked on. Where will attorneys come from for representation prior to approval? That's a great question. There's some local programs that are trying to create that. There's a work group in Hillsborough County that's applying for some funding to be able to pay attorneys to do that. Some of the domestic violence shelters have staff attorneys who are currently providing that type of legal assistance pre-petition. And some of the regional counsel office they're able to have their attorneys represent their former clients who are back and under investigation but don't have an open case yet. So I think there's lots of opportunities, but there's not a statewide, yes, everybody is going to be able to do it. I think the new statute is confusing as to whether the GAL actually represents the child. Yes. And I'm happy to talk to anybody offline about the complexities of that. With the responsibility as the fiduciary, does the GAL office have the duty to ensure children are getting the benefits they are entitled to? I sure would hope so. I'm not sure that was specifically outlined in the law, but they have accepted a responsibility, a fiduciary responsibility, and in many places are opposing the appearance of other attorneys for children. So the tricky thing here is the guardian ad litem, statewide guardian ad litem office, and anyone appointed as a guardian ad litem has sovereign immunity. They cannot be sued or collected damages for acting in their official capacity. An attorney for a child has the ability to be sued for malpractice. So if they mess up something and a child doesn't get the benefits that they need, someone could sue them in malpractice. So, which is why all the legal aid programs offer malpractice insurance. And I hope the rest of you have your own private malpractice insurance, because that is a major difference between the guardian ad litem who cannot be sued and a child's attorney who can be sued. The medical training, I can't answer. I think the adoption home study, again, I don't think it's required. I think the other home studies substitute. What if the kid does not want a GAL? That's a conversation between the kid and the court. The law says the GAL has to be appointed. I don't think it says they have to stay on the case, but that's going to be an interesting thing to be kind of tracked in. And the correction is a kid who has an attorney doesn't want a GAL. So if a child has an attorney and wants something from the court, whatever that something is, the attorney can make that motion. So if the kid doesn't want a GAL, then the kid's attorney can make the motion that the GAL be discharged, and the court hears it as it would any other pending issue. Young adult EFC representation. So young adults who had court-appointed attorneys because of their disability, or their special needs category under 18, that representation continues past the age of 18 because extended foster care is a continuation of care, and the definition of child is extended. So the definition of the child in the court appointment statute 3901-305 is extended to young adults in EFC. Young adults who are in EFC who did not have a court-appointed attorney prior to 18 don't acquire a new right to get a court-appointed attorney, but they are adults. And they, like children who are younger than 18, have the capacity to locate and retain attorneys. Some parts of the state have tremendous resources in legal aid and pro bono projects and pro bono attorneys, people in the community who are willing to represent kids. Those kids have a good shot of getting representation. Other parts of the state, those resources aren't there. I think, Geori, did I miss? I know I really jammed through things, and I am happy to stay around or talk to people.
Got everything. If we missed any questions, it just got lost in the Zoom, so we apologize.
Okay. Okay, well, we're right on time. We're around, you know where to find us. And thank you, everybody. We appreciate your sticking with us through. I know I sped through it, but it's important stuff for you to have. You are on mute, Alexis.
I said this was a wonderful training, as always, is any time that I partner with Florida's Children First. So thank you for bringing this important knowledge to our community. There are many accolades certainly coming through the chat. Just thank you for all the work that you do and taking the time to share your knowledge with us. With that being said, anybody who needs anything, my email address is in the chat. You will receive an email from Zoom within 24 hours with a copy of this recording and the CLE information. You need a certificate of attendance, reach out to me directly. I echo what Robin said. I'm here too for anything that I can help with.
And if you don't see it in your email tomorrow, look in your spam filter.
Yeah, absolutely. Because the
That's where
email
my
will come from Zoom, not my email address, which can, be overlooked easily. All right, everybody. Well, thank you very much. Have a great rest of your day, and we'll hopefully see you all at the next training.
Thanks.
Bye.
Bye-bye.